Are there any senators wishing to vote or change their vote?
What's the number again?
And are there any senators wishing to vote or change their vote? If not, let's see, the ayes are 60, the nays are 39, and the amendment passes. Okay. Under the previous order, there will be 2 minutes of debate equally divided prior to a vote in relation to amendment number 1481 as modified, offered by the senator from Ohio, Mr. Brown. This amendment is subject to a 60-vote threshold.
Mr. President.
The senator from Ohio, may we have order?
Mr. President, the amendment that Senator Merkley and I proposed would require all senators and their senior staff to sell individual stocks that create conflicts or place their investments in blind trust. You can still invest in broad-based mutual funds. You can keep your ownership interest in your family farm or small business. If you're setting up a blind trust, you can instruct the trustee to hold on to your stock in your family company. Current Senate ethics rules require committee staff making more than $25,000 a year to divest themselves of any substantial earnings which may be directly affected by the actions of the committee for which it works. All Senator Merkley and I are saying is that members of the Senate should hold ourselves to the same standard that we already require of our committee staff and executive branch employees. And as Senator Merkley said, baseball players can't bet on their games. We should not be able to hold stock in individual companies and then vote on issues that affect our holdings. I ask for a yes vote.
Mr. President.
Senator from Maine.
Mr. President, I'm going to yield half the time in opposition to Senator Toomey.
Senator from Pennsylvania.
I thank the senator from Maine. I disagree with the fundamental premise of this amendment. I don't think we should all be forced to divest of all of our holdings, but I think it's worse than it was characterized by my friend from Ohio. Worse in the sense that as I read the definition of the securities that would be covered, and as the securities attorneys have advised us on this, we would be required to divest ourselves even of our investment in a small family-owned business, a business that perhaps has absolutely no market whatsoever for the equity, and we would nevertheless be forced to sell that where there is no buyer. I think that's a very unreasonable standard, and so I would urge a no vote on this amendment.
Mr. President.
Senator from Connecticut.
Mr. President, I rise to oppose the amendment. This amendment would take Congress from where we have always been and are going to be better after this law passes in pursuit of disclosure and transparency, sunshine as the best guarantee of integrity. This would be the first time that I'm aware of that in the legislative branch we would require divestment of personal holdings. And for that reason, I oppose the amendment. I think, remember that in the underlying bill, we have increased the public's access to information about our holdings and our transactions. And ultimately, that knowledge ought to be enough to guarantee the public or to energize the public to make sure that we are following the highest ethical norms. Divestment, in my opinion, is a step too far.
As for the yeas and nays, Mr. President.
Is there a sufficient second? Appears to be. The clerk will call the roll.
Mr. Akaka. Mr. Alexander. No. Ms. Ayotte. Mr. Barrasso. Mr. Baucus.
Number 1 and 2 after you announce the vote on this amendment, and then
Mr. Beckich. Mr. Bennett. Mr. Bingaman. Mr. Blumenthal. Mr. Blunt. Mr. Bozeman. No. Mrs. Boxer. Mr. Brown of Massachusetts. Mr. Brown of Ohio. Mr. Burr. Ms. Cantwell. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Chambliss.
I guess when it's all...
Mr. Coates.
Anytime...
Mr. Coburn. Mr. Cochran. Ms. Collins. Mr. Conrad. Mr. Coons. Mr. Corker. Mr. Cornyn. Mr. Crapo. Mr. Dement. Mr. Durbin. Mr. Enzi. Mrs. Feinstein. Mr. Franken.
Aye.
Aye. Both of you aye.
Seems to me if staffers have to do it, why shouldn't we?
Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mrs. Hagan. Mr. Harkin. Mr. Hatch. Mr. Heller. Mr. Hoven. Mrs. Hutchison. Mr. Inhofe. Mr. Inouye. Mr. Isaacson, Mr. Johans, Mr. Johnson of Wisconsin, Mr. Johnson of South Dakota. Mr. Carey. Mr. Kirk. Ms. Klobuchar. Mr. Cole. Mr. Kyle. Ms. Landrieu. Mr. Lautenberg. Mr. Leahy. Mr. Lee. Mr. Levin. Mr. Lieberman. Mr. Lugar. Mr. Manchin. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Ms. Mikulski. Mr. Moran. Ms. Murkowski. Mrs. Murray. Mr. Nelson, Nebraska. Mr. Nelson of Florida. Mr. Paul. Mr. Portman. Mr. Pryor. Mr. Reed of Rhode Island. Mr. Reed of Nevada. Mr. Risch. Mr. Roberts. Mr. Rockefeller. Mr. Rubio. Mr. Sanders. Mr. Schumer. Mr. Sessions. Mrs. Shaheen. Mr. Shelby. Ms. Snowe. Stabenow. Mr. Tester. Mr. Thune. Mr. Toomey. Mr. Udall of Colorado. Mr. Udall of New Mexico. Mr. Vitter. Mr. Warner. Mr. Webb. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Senators voting in the affirmative: Akaka, Blumenthal, Brown of Massachusetts, Brown of Ohio, Casey, Franken, Heller, Carey, Klobuchar, Cole, Levin, Manchin, McCaskill, Merkley, Sanders, Stabenow, Udall of Colorado, and Udall of New Mexico.
No.
Senators voting in the negative: Alexander, Ayotte, Barrasso, Beckidge, Bingaman, Blunt, Bozeman, Boxer, Burr, Coates, Coburn, Collins, Corker, Cornyn, Crapo, DeMint, Durbin, Enzi, Feinstein, Gillibrand, Graham, Hagan, Hatch, Hoeven, Inhofe, Isaacson, Johans, Johnson of Wisconsin, Johnson of South Dakota, Kyle, Landrieu, Lautenberg, Leahy, Lee, Lieberman, Lugar, McCain, McConnell, Mikulski, Moran, Murray, Nelson, Nebraska, Paul, Portman, Reed of Nevada, Risch, Roberts, Rockefeller, Rubio, Schumer, Sessions, Shelby, Tester, Thune, Toomey, Vitter, Warner, and Wicker. Mr. Grassley, no. Mr. Baucus? Mr. Baucus, no. Mr. Akaka? Mr. Akaka, no. Mr. Cardin? No. Mrs. Shaheen? Aye. Mr. Wyden? Aye. Mr. Noe? No. Mr. Webb? No. Mr. Cochran? No. Mr. Nelson? Mr. Nelson of Florida? No. Mr. Chambliss? No. Mr. Bennett? No. Mr. Rockefeller? Aye. Mr. Conrad? No. Mr. Menendez? Aye. Mr. Harkin? No. Mr. Cole? No. I have to count again. Mrs. Hutchison? Aye. Mr. Reed of Rhode Island? Aye. Ms. Snow? Aye. Mr. Whitehouse? Aye. Ms. Murkowski? Aye. You going to do it again, Timmy? Mr. Rockefeller? No. Mr. Coons? No. Mr. Pryor?
Aye.
Mr. Carper?
Aye.
Ms. Cantwell?
No.
Are there any senators wishing to vote or change their vote? Since there aren't, on this vote, the yeas are 26, the nays are 73 under the previous order requiring 60 votes for the adoption of this amendment. The amendment is not agreed to. Under the previous order, the substitute amendment as amended is agreed to. The clerk will read the bill for the third time.
Calendar 301, S. 2038, a bill to prohibit members of Congress and employees of Congress from using non-public information and so forth for other purposes.
Under the previous order, there will now be 2 minutes of debate equally divided prior to a vote on the passage of the bill as amended. Everyone wish to yield their time?
Mr. President, I thank everybody. It's been a good open process. I think we had a good bill that came in. It's better now, and I yield back the remainder of my time.
Mr. President,
The senator from Maine.
we will make our speeches after the vote.
Very well.
I thank my colleagues.
The question occurs on the passage of the bill as amended. Is there a sufficient second? There is. Clerk, call the roll.
Mr. Akaka. Mr. Alexander. Ms. Ayotte. Aye. Mr. Barrasso. Mr. Baucus. Mr. Begich.
Okay.
Mr. Bennett. Mr. Bingaman. I got you. I got you. Sure. Thank you.
Make you all a little bit more patient.
Rockefeller. Got you.
We had an impatient group back there.
Did you get there?
I did.
Say hi to the girls.
Mr. Bingaman, Mr. Blumenthal.
Keep going, keep going.
Got you, sir. I got you.
Y'all have worn us out today.
Thank you. Mr. Hoven. Hoven, Udall. Gotcha. Cochran. Mr. Blunt. Mr. Bozeman.
Are you going out to... I'm going home. I am going tonight, but I have a 9:30 flight. I missed my... I didn't think I could.
Mrs. Boxer. Mr. Brown of Massachusetts. Mr. Brown of Ohio. Mr. Burr. Ms. Cantwell. Mr. Cardin, Mr. Carper. Mr. Casey.
Next one next. Oh, sorry. Yep. Sorry, I wasn't ignoring you.
Mr. Coates, Mr. Coburn, Mr. Cochran.
You see my note? I do.
I did get you.
Oh, yes, we got it.
I'm an eye for the gulag.
Ms. Collins. Mr. Conrad, Mr. Coons. Mr. Corker, Mr. Cornyn, Mr. Crapo, Mr. Dement, Mr. Durbin, Mr. Enzi, Mrs. Feinstein, Mr. Franken, Mrs. Gillibrand.
Look at Coons behind you. Behind you. He's in the chair.
Yeah, gotcha.
Have a nice weekend,
I've
sir.
been Ray on everything.
Mr. Graham, Mr. Grassley, Mrs. Hagan, Mr. Harkin, Mr. Hatch, Mr. Heller, Mr. Hoven, Mrs. Hutchison, Mr. Inhofe, Mr. Inoue, Mr. Isaacson, Mr. Johans, Mr. Johnson of Wisconsin, Mr. Johnson of South Dakota, Mr. Carey. I got you. Mr. Kirk, Ms. Klobuchar. Mr. Cole, Mr. Kyle. Ms. Landrieu. Mr. Lautenberg, Mr. Leahy, Mr. Lee. I did. Mr. Levin, Mr. Lieberman, Mr. Lugar, Mr. Manchin, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Ms. Mikulski, Mr. Moran. No, listen good to me.
I'm over here.
Ms. Murkowski. Mrs. Murray.
Yeah.
Mr. Nelson of Nebraska, Mr. Nelson of Florida, Mr. Paul, Mr. Portman, Mr. Pryor, Mr. Reed of Rhode Island, Mr. Reed of Nevada, Mr. Risch, Mr. Roberts, Mr. Rockefeller, Mr. Rubio, Mr. Sanders, Mr. Schumer, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Snow, Ms. Stabenow, Mr. Tester, Mr. Thune, Mr. Toomey, Mr. Udall of Colorado, Mr. Udall of New Mexico, Mr. Vitter, Mr. Warner, Mr. Webb, Mr. Whitehouse, Mr. Wicker, Mr. Wyden. Senators voting in the affirmative: Akaka, Alexander, Ayotte, Barrasso, Baucus, Begich, Bennett, Blumenthal, Blunt, Bozeman, Boxer, Brown of Massachusetts, Brown of Ohio, Cantwell, Cardin, Carper, Chambliss, Coates, Cochran, Collins, Conrad, Coons, Corker, Cornyn, Crapo, Dement, Durbin, Enzi, Feinstein, Franken, Graham, Grassley, Hagan, Hatch, Heller, Hoeven, Hutchison, Inouye, Isaacson, Johans, Johnson of South Dakota, Carey, Klobuchar, Cole, Lautenberg, Leahy, Lieberman, Lugar, Manchin, McCain, McCaskill, Menendez, Mikulski, Moran, Murkowski, Murray, Nelson of Nebraska, Nelson of Florida, Paul, Portman, Reed of Rhode Island, Reed of Nevada, Risch, Roberts, Rockefeller, Rubio, Sanders, Schumer, Sessions, Shaheen, Shelby, Snow, Stabenow, Tester, Thune, Toomey, Udall of Colorado, Udall of New Mexico, Vitter, Warner, Webb, Whitehouse, and Wyden. Mr. McConnell. Mr. McConnell. Aye. Mr. Inhofe. Aye. Mr. Lee. Mr. Lee. Aye. Mrs. Gillibrand. Mrs. Gillibrand. Aye. Ms. Landrieu. Ms. Landrieu. Aye. Senators voting in the negative: Bingaman, Burr, Coburn, Mr. Wicker, aye. Mr. Johnson. Mr. Johnson of Wisconsin, aye. Casey. Mr. Casey, aye. Mr. Kyle. Mr. Kyle, aye. Mr. Levin, aye. Mr. Harkin. Mr. Harkin, aye. Mr. Pryor, aye. Mr. Merkley? Aye.
Are there any senators in the chamber wishing to vote or to change their vote? Seeing none, on Senate Bill 2038 as amended, the yeas are 96, the nays are 3. The bill is passed.
Madam President.
The senator from Utah.
Madam President, I ask unanimous consent the Senate proceed to a period of morning business with senators permitted to speak therein for up to 10 minutes each.
Without objection.
I would ask unanimous consent that I be permitted to deliver my full speech regardless of the time.
Without objection.
I thank you, Madam President. Madam President, our nation faces grave challenges. We're looking at our 4th straight trillion-dollar deficit. Our credit rating has been downgraded. Public spending is out of control. The nation demands leadership. At some moments in our nation's history, at moments of crises, leaders have emerged, put partisanship aside, and worked to solve our greatest challenges. Though our current president has compared himself to both Franklin Roosevelt and Abraham Lincoln, his leadership is falling well short of their examples. Instead of taking the reins and making tough choices when presented with our current fiscal crisis, he has decided to put politics first. He always puts politics first. Just this morning at the National Prayer Breakfast, the President took what has always been a nonpartisan opportunity for national unity and used it to promote his political agenda. He suggested to the attendees that Jesus would have supported his latest tax-the-rich schemes. With due respect to the President, he ought to stick to public policy. I think most Americans would agree that the Gospels are concerned with weightier matters than effective tax rates. As long as the President has decided to assume the role of theologian-in-chief, he would do well to put tax policy aside and consider the impact of one of his latest Obamacare mandates. Secretary Sebelius' decision to force religious institutions over the strong objections of churches and universities representing millions and millions of Americans to provide insurance coverage for abortifacient drugs and contraceptives to their employees will require these groups to violate their deepest held religious beliefs. The President's comments this morning share more with political strategy than they do the religious beliefs of most Americans. In 2008, the President declared that his nomination was the world historical moment when the rise of the oceans began to slow and our planet began to heal. Someone needs to remind the President that there was only one person who walked on water, and he did not occupy the Oval Office. Madam President, this drive to politicize every aspect of our institutions and public discourse took a serious and dangerous turn last month with the President's appointments to the Consumer Financial Protection Bureau, or CPFB, and to the National Labor Relations Board, or NLRB. Last week in his State of the Union address, President Obama said that Americans deserve a government that plays by the rules. Yet his appointments of January 4th, just one day into a 3-day Senate recess, failed to meet his own standard. Those unlawful appointments are the latest example of how he is willing even to undermine the Constitution and weaken our government institutions to get what he wants. They are a deeply cynical political ploy that puts his own ideological wants and electoral needs above our Constitution and rule of law. The Constitution, not the President's political agenda or re-election strategy, sets the rules we must live by and play by. In the regular order of the appointment process, the President nominates, but the Senate must consent for him to appoint. The President may not get his way every time, but this is one of many checks and balances in our system to make sure that one part of the government does not gather too much power. The Constitution also allows the President temporarily to fill, quote, vacancies that may happen during the recess of the Senate, unquote. Because these so-called recess appointments do not require Senate consent, however, they are supposed to be an exception to the confirmation rule. The most obvious requirement for a recess appointment is that there actually be a real recess. Needless to say, if the President alone could define a recess, he could make recess appointments during every weekend or lunch break. The exception would swallow the rule, and the President could shut the Senate out of the process altogether. Our Constitution refers to the recess of the Senate, not to a recess of the President's imagination or his lawyer's creation. And under the Constitution, the Senate has authority to determine its own procedural rules, including the what, when, and how long of Senate recesses. I won't go into all the twists and turns of recess appointment history. For decades, however, the standard has been that a recess must be longer than 3 days for the President to make a recess appointment. The Constitution, for example, requires the consent of the House or Senate for the other body to adjourn for more than 3 days. The Congressional Directory, which is the official directory of Congress, defines a recess as, quote, a break in House or Senate proceedings of 3 or more days, including Sundays, unquote. The Senate's own website has the same definition. The Clinton administration argued in 1993 that a recess must be longer than 3 days. The Clinton administration took that position. And in 2010, the Obama administration's own Deputy Solicitor General said this to the Chief Justice. John Roberts, when arguing before the Supreme Court, quote, our office has opined the recess has to be longer than 3 days, unquote. Let me repeat that. The Obama administration told the Supreme Court that a recess must be longer than 3 days for the President to make a recess appointment. The Democratic majority in this body has endorsed this same standard. On November 16, 2007, the majority leader said, quote, the Senate will be coming in for pro forma sessions during the Thanksgiving holiday to prevent recess appointments, unquote. The 4 brief sessions he scheduled chopped the Thanksgiving break into recesses of, you guessed it, 3 days or less. So did the 5 sessions he scheduled during the Christmas break. This new tactic worked, and President Bush did not make another recess appointment for the rest of his presidency. There is no record that then-Senator Barack Obama objected to this tactic in any way. He did not criticize it as a gimmick. He did not opine that the President could still make recess appointments despite these pro forma sessions. He did not even suggest that pro forma sessions did anything other than create new, shorter recesses. That is, after all, the only way the pro forma sessions can block recess appointments. As far as I can tell, Senator Obama fully supported his party using pro forma sessions to block recess appointments. Finally, consider this. Our Rule 31 requires that pending nominations be sent back to the President whenever the Senate, quote, shall adjourn or take a recess for more than 30 days, unquote. Pursuing his strategy to prevent appointments during the August 2008 recess, the majority leader scheduled no less than 10 pro forma sessions during that period. As a result, and that was the Democrat majority leader, by the way, as a result, because each pro forma session began a new recess of less than 30 days, the Senate executive clerk did not return any pending nominations to the President. Now, the standard here is clear. Pro forma sessions create new recesses. Just read the congressional record. Each pro forma session begins with the words, quote, the Senate met, unquote, and ends with the statement that the Senate, quote, stands in recess, unquote, until a specific date and time. I don't know how much clearer it could possibly be. The Senate must adjourn for more than 3 days for a President to make a recess appointment. The Senate has endorsed this standard. The Democratic majority has endorsed this standard. Senator Barack Obama endorsed this standard. And President Barack Obama's administration has endorsed this standard. A new recess begins when a Senate session, even a pro forma session, ends. But that was then. This is now. The Senate met on January 3, 2012, as the Constitution requires, to convene the second session of the 112th Congress. The congressional record states that the Senate adjourned at 12:02 until January 6th at 11 a.m. Now, I know that we see some fuzzy math here in Washington from time to time, but this is pretty simple. That was a 3-day recess, which was not long enough to allow a recess appointment. The very next day, however, President Obama installed Richard Cordray as head of the Consumer Financial Protection Bureau, and he also installed 3 members of the National Labor Relations Board. These appointments were clearly unlawful because a sufficient recess did not exist. These appointments violated the standard that President Obama himself endorsed when he served in this body, and they violated the standard that his own administration endorsed before the Supreme Court. Senate Democrats routinely attacked President George W. Bush for supposedly creating what they called an imperial presidency. That criticism was bogus for a host of reasons, but I can only imagine how the majority would have howled had President Bush made recess appointments the day after those pro forma sessions in 2007 and 2008. They would have denounced him for defying the Senate, for an unprecedented power grab, and for destroying the checks and balances that are so important in our form of government. They would have taken swift and firm measures in retaliation. Who knows? But they might even have gone to the court over it. But President Bush respected the Senate, and whether he liked it or not, declined to make recess appointments when there was no legitimate recess. President Obama apparently has no such regard for this body, one which he was honored to be a member of. And to be clear, that means he has no such regard for the Constitution and its system of checks and balances. He only wants his way. His political mantra last fall that he can't wait for Congress to enact his agenda has now resulted in these politicized appointments that violate our deepest constitutional principles. No doubt some on the other side of the aisle will respond that the Office of Legal Counsel at the Department of Justice has issued a memo justifying these recess appointments. Well, as Paul Harvey used to say, here is the rest of the story. That memo was issued on January 6, 2 days after President Obama made these unlawful recess appointments. I had understood OLC's role as giving objective advice before decisions were made. During this after the fact just looked like it's a method of trying to justify rather than inform this controversial decision, especially when the memo admits that it addresses a novel issue with, quote, substantial arguments on each side, unquote. The most egregious flaw in the OLC memo is that it addresses the wrong question. The question that OLC should have answered is why a pro forma session, like any other session, does not start a new recess. That is the real question here. OLC simply ignored that question entirely, and I'm not at all surprised. The obvious answer is that a pro forma session does begin a new recess, and then OLC would have had to justify the President making a recess appointment during an unprecedented 3-day recess. Rather than address that necessary question, the OLC memo instead addressed whether the President may make recess appointments during a longer recess that is, quote, punctuated by periodic pro forma sessions, unquote. I'd like to know who made up this characterization of pro forma sessions as merely procedural punctuation marks, but a cliche like that is no substitute for a real legal argument. If that is the most egregious flaw in the OLC memo, its most egregious omission might be failing even to mention, let alone explain away, the Obama administration's endorsement of the 3-day standard before the Supreme Court. In 1996, the Clinton Office of Legal Counsel advised that making appointments during a 10-day recess would, quote, pose significant litigation risks, unquote. In this new memo, the Obama OLC admits that these appointments during only a 3-day recess, quote, create some litigation risks, unquote. They admit that. The memo, of course, does not attempt to explain how appointments during an even shorter recess somehow pose less litigation risk. Either way, litigation may just be where this controversy is headed, and I certainly hope so. Just like our Democratic colleagues accused President Bush of creating an imperial presidency, they accused his administration's Office of Legal Counsel of helping him to do it. They attacked OLC for being his advocate rather than an objective, neutral advisor. Well, nothing OLC did for President Bush looked anything like what we see today. This memo reads like a brief by the President's personal lawyer. Now, we all know that Justice Department lawyers are not the President's personal lawyers. Now, Madam President, when President Obama decided to make these appointments, the person who should have been the most outraged was the Senate Majority Leader. After all, as the highest-ranking officer in the chamber, he should have been particularly defensive of the rights and prerogatives of the Senate and should have opposed any effort on the part of the executive to undermine the Senate's role in the confirmation process. Unfortunately, that is not what happened. Since the time the appointments were made, the Senate Majority Leader has, on multiple occasions, publicly endorsed the President's decision to ignore precedent and bypass the Senate. He did so on television in mid-January, and again just this week here on this floor. The Majority Leader's decision to support and indeed applaud the President in this case is troubling, given that, as I mentioned a few minutes ago, it was under his leadership that the Senate began to use pro forma sessions for the specific purpose of preventing President Bush from making recess appointments. The Majority Leader has acknowledged this to some extent, but his explanation as to why he's taking these apparently contradictory positions is unclear and somewhat hard to follow. Madam President, we need a better explanation from the Majority Leader because from the vantage point of many here in the chamber, it appears that his position on the efficacy of pro forma sessions and the constitutionality of recess appointments varies depending upon who is occupying the White House. No leader in this body should ignore this question. And frankly, our leaders should be standing up for the Senate against the White House on this matter. Well, I hope that's not, I hope that it isn't true that the constitutionality of recess appointments varies depending on who is occupying the White House. I hope that I have simply misinterpreted what appear to be plain statements, both past and present, on the part of the Majority Leader. That is why I, along with 33 of my colleagues, have submitted a letter to the Majority Leader asking him to clarify his position on these appointments. Specifically, the letter asks him to state whether he believes the pro forma sessions have any impact on the President's recess appointment power. It also asks him to clarify whether he believes that President Bush had the constitutional authority to make recess appointments like the ones recently made by President Obama, and why, if he believes these recent appointments are constitutional. He instituted the practice of using pro forma sessions in the first place. Why did he do that? Finally, the letter asks the Majority Leader to state specifically whether he agrees with the President's legal argument that the Senate was unavailable to perform its advice and consent functions during the recent adjournment period. I have a copy of the letter here, Madam President, and I ask unanimous consent that that letter, signed by 33 senators, be entered